When a person dies without a will in the state of Maryland, they die intestate. That's what the law refers to as a person who dies without a will, and there's a statute called the intestacy statute that governs the distribution of their estate, and it generally will pass their estate through and down to lineal descendants. There are a whole bunch of different ways that breaks out. For instance, if a son or daughter passes away and their parents are surviving, their parents are the primary beneficiaries. These and many other things are part of what we help families with in these difficult times. The estate is the legal fiction that occurs after a person dies. And basically, if I were to die, all of the accounts, property, cars, etc., would all be owned by someone, and that legal entity is referred to as the estate. The estate is administered by a person called the personal representative, and part of those duties are to aggregate all of those assets, the financial assets, the personal property, everything else that a person has accumulated in their lifetime, and that flows ordinarily into the estate. Again, there are many different gesticulations on what may be in the estate. If a person has a trust, they might have both a trust and an estate, and it all depends on the circumstances. We help people plan for that before they die and help their families to administer the estate. In the state of Maryland, the estate administrator is referred to as the personal representative. That's the person who's responsible for discharging all the duties of filing papers with the court, making sure that property is aggregated appropriately and distributed to the heirs, whether it be under the intestacy statute or in accordance with the will. And that's a position of trust that is an important selection process for every family to consider. In many cases, we work with a personal representative to help them administer the estate, or in many, many cases, we are asked by the families to serve as the personal representative to discharge that fiduciary duty, make sure the property is distributed appropriately, and that we file with the court all necessary documents or litigate any issue. In Maryland, intestate succession refers to the process in which, if you die without a will, your estate will be administered. And that is how your assets will flow to your heirs. So, first thing is, if you die without a will, which is not preferred, we do want people to have wills. It makes a lot of things more clear, easier to administer. But if you die without a will, or a loved one does, those assets don't just go nowhere. They go to that person's lineal descendants. So if I had children, it would go to my children. If I die without children and my parents are still alive, the assets under the statute would flow up to my parents and then down through my bloodline. And in the worst possible case, where a person does not have any intestate beneficiaries, the last position would be where the state of Maryland would take that property. That is why we advise in every single case, no matter how small or large your estate, it pays to have a well-written, even if it's a simple will, which we're glad to help with.